So let's open it up to general audience questions then. And we have a person on my left side and with that microphone too.
Michael, very nice talk tonight. Thank you. Is this issue of positive rights versus negative rights, would that be a constitutional fight?
Where it's coming up at the federal level. And in particular, you see a lot of the current administration talking about the phrase is reinterpreting the Constitution from the perspective of positive rights. So what they're actually doing is looking for the ability to enact these, I'm trying not to be too political about it, social policies and programs within the existing framework of the Constitution. And that's the methodology.
Okay, I thought you said, I thought you were inferring that the positive rights were coming out of New York State.
No, what I'm inferring is that this is becoming more of a new paradigm for looking at and defining rights. And you are seeing it in New York State too. I mean, certainly the call for a ban on hydrofracking under the auspices that we can't do this until there's zero risk is essentially a declaration of a positive right. We're free from risk. The government's going to protect us from that. And it becomes now a government mandate to do it. That's the paradigm shift, if you follow me. Formerly, we would have said it's got to be a negative right. As a property owner, you enjoy the right to drill and explore. As a company who leases that right, you step into the shoes of, and what you have to do is you have to conform to the regulatory policy that we have. You follow the steps, and the outcome, be it as it may. Now it's heading towards the reverse. It's not there yet, but it's going towards a system where you have to tell us ahead of time that there's no impact, or you can't do it. That's the paradigm shift.
Thank you.
Oh, could you wait a second?
Correct.
Spacing laws and compulsory integration?
Yes and no. Pennsylvania actually does have a compulsory integration statute. There's a quirk to it in that it is limited to, its use is limited to all wells drilled below the top of, I believe it's the Onondaga limestone. It's the formation below the Marcellus. So while the statute does exist, it's been on the books since the 1950s, it's actually not used as it relates to the Marcellus Shale. And in Pennsylvania, companies drilling shallower wells have been what they call line drilling each other for years, where quite literally, as you saw on Spindletop, you've got a line of wells going down one property line and a line of wells going down the other because of drainage issues. That is actually happening in the Marcellus. Less between companies and more between companies that have leased rights and unleased property owners next to them. They'll drill within 200, 300, 400, 500 feet of the property line if they can't get those leases, and what it essentially ends up doing is it orphans that acreage. I mean, after an area's been developed, even if there's undeveloped acreage in the middle of it, the economic incentive for a company to go in, lease that property, and develop it's pretty low because the area around it has already been developed, presumably with the impact of either having drained that property or they don't have the ability to develop the infrastructure that they need on the scale that they need to make the wells economic.
Are there published figures as to how many wells are being drilled in Pennsylvania?
Oh, yes. Oh, I'm sorry. The second question was, are there published figures about how many wells are drilled in Pennsylvania? And the answer is most certainly. This is a closely followed issue. My best recent figures are that to date they've drilled about 2,500 horizontal wells targeting the Marcellus Formation in the last 3 years. The Pennsylvania Department of Environmental Protection is the permit issuing agency, and those figures are publicly available. Go on their website.
Based on what you're saying about the New York the existing regulatory framework in New York with regard to wetlands legislation, historic preservation legislation, et cetera. If folks in New York are looking across the line at what's happening with the drilling in Pennsylvania and don't like what they see, would your position be that they're misinterpreting what they're seeing or perhaps making too much of what they're seeing? Or would your position be in New York, it wouldn't be like that because our regulatory framework is different?
It's the latter. Geologically and from an engineering perspective, the wells are the same, the formation is the same, the process of drilling is going to be the same. In terms of the density of wells, infrastructure, it's going to be vastly different because of the regulatory structure that we have in place in New York. At the state level, for instance, Pennsylvania, while they're drilling wells, multiple wells from a common pad for efficiency, New York has that as a regulatory mandate. So the well density is determined by the state and by the regulations. That is taking into consideration all those other facets that go into siting of wells. So I think it's a little bit of both. One, the regulatory structure in New York is much more robust than it is in Pennsylvania. And two, just because of the development and the nature of the communities down there, you're going to simply see a lower density of wells because they have to take into consideration all the setbacks and spacing and stuff in the more populous area. Which is in and of itself interesting when you refer to the southern tier of New York as populated.
A question on that 330-foot setback from horizontal wells.
Sure.
Is that related to that when you do a fracture from the wellbore, that it's basically only going to penetrate 330 feet into the formation?
At the time, that was basically the engineering basis for it, is that the minimum setback would be 330 acres. And again, at the time, it was a struggle, or a compromise, I should say, between the industry that would have looked for a less restrictive setback and the Department of Environmental Conservation, who was looking to be as conservative as possible. What ultimately will happen, particularly with the common pad development, is that internal to the unit, the setbacks will be determined by the efficiency of the hydrofracking process. And on a single well basis, it'll be 330 or whatever the industry can determine their fracking density to be. If it's 400 feet, if it's 500 feet, you'll see the wells moving. And what and finish out the question, because it's from wellhead to wellhead or wellbore to wellbore, what you end up with is 330 feet on the outside and 660 feet in between. Because it's 330 feet from the wellbore over. If you have another well, it's another 330 feet, so they're actually 660 apart.
Yeah, but the idea is that they sort of have an idea of how far the fracture actually travels into the
Yeah,
shale.
it's based on drainage, theories of drainage.
Why is the moratorium on? Because of the contamination, or because they can't decide how they want to drill? I mean, what's the percentage of water that's being contaminated, and how far along does that go? Like, if the person that has the property, they drill, their water can be contaminated, and everybody around them is contaminated by this? I mean, last week he said that the brine is the same or similar to what we use to salt our roads.
That's where a lot of it comes from.
So then, isn't, with the technology and with the chemists that we have in this country, isn't there some way they could neutralize whatever they're using to drill that well?
Well, one of the issues is, and this is not meant to be a criticism of you individually, but it's become part of the public perception that there will be contamination. And in reality, there isn't. That's the issue. The process of hydrofracking has been studied time and again. And as Dr. Smith referred to, there's never been a confirmed incident of groundwater contamination caused by hydrofracking. So it began as a concern, quite literally a concern, i.e. this might occur, ergo, we need to study it and come up with mitigation measures before anybody had actually demonstrated that it does occur.
So then where do these people get the flames coming out of their ponds and everything? That's just a natural thing like he explained last week? Or is this an error on the part of the companies that drilled?
For example, the picture that Dr. Smith showed last week was from a bathtub in Saratoga. There's not a natural gas well or an oil well within tens of miles of that person's property. And if you heard of the film Gasland, okay, there's a very dramatic scene in the film Gasland where the individual lights his tap water on fire. That's actually from Colorado, and the Colorado Regulatory Agency has investigated that, and the gas is not, it's biogenic. It's not natural gas. I mean, the thermogenic natural gas that we're drilling for actually comes from the surface. So to be blunt about your answer, most of those images are propaganda.
My question is, if there's politics driving a positive set of rights, I'm not blind to the fact that there's politics on the other side driving business and business interest. There's a gold mine, so to speak, in New York of drilling area.
Mm-hmm.
And where does that politics lie? I mean, I can't imagine that businesses have sat silent in New York State and not done anything about getting their hands in the political process and moving the moratorium, well, away, so to speak. I mean, who is it? Simply the governor who has to lift this? Is it outside? Who lifts the moratorium? How does that come about? Where does the politics lie on the other side? Because there's always two sides to the coin.
Mm-hmm. The overall industry response to it has been to move. They've actually left. The two largest operators in Pennsylvania were the two largest leaseholders in New York. Talisman Energy actually had its corporate offices in Horseheads, New York, in Chemung County. They quite literally moved. They abandoned their offices, went across the state line, and are now the largest drilling operator in Pennsylvania. So largely that's been the big company response. The historic industry that's been here for a long time, they're about as active as they can possibly be. In fact, that's one of the reasons that I do these lectures is I don't get paid for them. I do them because I believe in the process. We've been in Albany. In fact, we're in Albany as often as we can possibly be to present this information to the governor's office, the governor's staff, the incoming governor's staff, to try and move this process forward. Right now, it doesn't seem to have an end in sight. It seems to be at the political will of the governor and the new commissioner of the DEC. I do think that the SGEIS is on the verge of coming out. The target date of June 1st has moved. Now it's a little bit vague, sometime in June, maybe July, but I do think this summer it's going to happen.
Okay.
Not really a question, relating to what you said a couple of seconds ago, I personally know at least two people. I live in Collins Center, Southern Erie County. I know two people whose water is undrinkable. It was not undrinkable before the gas drilling, and it is now. Whether it's from hydrofracking or whether it's from a fracture in the wellhead, I have no idea. But there are people who are impacted by this.
Each one of those cases should be, and I emphasize should be, reported
It's been
to
reported.
the
and,
Department of Health.
And no one seems to be interested.
Unfortunately, when the reason that, sorry about that,
Okay.
the reason that they haven't been reported to the Department of Health and the reason that they can't really do anything about it is because the hydrofracking fluid is not brine. It's proprietary and it's often mixed with chemicals such as benzene, which has been proven. There have been people who have been sick who have been trying to get diagnoses from their doctors but haven't been able to do so because they've tried to get disclosed what exactly is in that fluid other than the benzene and whatnot. And they simply, the companies won't let them do it. So they they get seizure disorders and they get seriously ill, a lot of neurological disorders, and they can't find out because, I mean, why would the gas companies lobby so much money to the Bush administration, and when they passed for an exemption in 2005, this law was passed, why would they lobby for an exemption from the Clean Water Act if they didn't know that there was some sort of contamination going on? And not only that, there was a study when the panel... My question is...
Please try to keep it to questions, not comments.
Well, let's, I guess, address the comments. Let's see if I can remember them all. The first is about fracking fluid. There are multiple websites out supported by the industry where the industry now publishes the constituents of the fracking fluid by well. The New York State Department of Environmental Conservation requires material data safety sheets for all the chemical constituents of all the frac jobs. So the data is certainly available. I have heard this anecdotal evidence, as they call it, which of course is an oxymoron. Either it's anecdotal or it's evidence of people getting sick, and I'm the most sympathetic of anybody. That's why we have the Department of Health that acts as essentially the first responder to these issues. They investigate by law every single claim that's made. Any claims which require additional expertise are referred to the New York State Department of Environmental Conservation, and it's not my data, it's their data that says that these haven't been confirmed. So, not frankly sure how else to respond.
I'd like to go back to your positive-negative situation. There have been a number of communities that have passed local ordinances banning fracking, mining. I represent Wyoming County. Our information had always been that the mining and minerals law, in this instance, would supersede any type of home rule law. Could you give me a legal interpretation on that?
Yes, there have been a number of communities that have, let me restate the facts that you laid out. A number of communities have proposed to enact local laws. Very few have actually done it. I understand the town of Wales is very close or is contemplating it. The city of Buffalo actually did pass a ban on hydrofracking, entirely symbolic. Of course, no one was going to frack in Buffalo. There's nothing to frack there. Those laws haven't been challenged because largely they're irrelevant. In those areas where operations are ongoing or are potentially ongoing, and particularly we see this in the eastern part of the state, the town of Middlefield comes to mind. What we've seen is a lot of activity ramping up towards passing those ordinances and the inability to get any credible law firm to actually back them. And so one municipality did pass an ordinance. About 3 months later, it was taken off of the books. The town of Middlefield was very aggressive in redeveloping their zoning laws. They've now backed off. They've hired another law firm, and they're now in the process of quote-unquote studying the issue. It's been tabled. I think that any municipality that in an area where drilling and development is likely to take place does pass that statute, I think that the lawsuits will come swiftly and hard.
Yeah, Doctor, thank you. I'm very much interested in what you said. If I have a two-part question, if I could.
Sure.
One, I actually do know a family who is interested in potentially signing a lease.
Okay.
So I said to be very careful. I'm not much for fracking, I'll be honest with you, but that's my second part of the question. I wanted to know the recommendation you would give to that I could give to them as far as protecting their rights and what they could do as far as developing, if they're going to go ahead with it, it's their, what type of, especially with the regulation in Pennsylvania, it sounds like the first come, first served. They don't have the compulsory integration. So, what would you recommend them? They talked, like talking to their neighbors, they farming a coalition. I just wanted to know first what your thoughts on that would be.
My first reaction is diligence is the most important thing to do. I generally find talking to the neighbors across the fence is about the worst source of information you can imagine. That comes just from years of representing companies in lease negotiations and going through communities and knowing what the devils of the deal were, and then knowing what people have told them to be. They're often very different. In terms of being diligent, seek out a good lawyer. And I mean a lawyer that knows oil and gas law. There's not a lot of them out there, but there are some, and they're worth finding. One of the issues that happens here is that I think many property owners don't realize the value of that legal representation. It's expensive. This is probably the largest transaction that an individual landowner is ever going to enter into. And they need to treat it like a business transaction the same way the company's treating it as a business transaction. Go out, find out what the terms are in the marketplace, in the community. You have tremendous power when negotiating a lease, and what I'm actually seeing is, particularly in Pennsylvania, individuals are now, through the leasing process, putting in terms to protect their property, terms, additional terms for setbacks. I've seen terms for water handling, believe it or not. I've seen provisions relating to piping water in versus trucking water in. Not all companies are going to agree to those things, but there's a lot of options that you have, and it's all part of a negotiation process. And if you're not comfortable with it, don't do it, because you're going to deal with it for a long time. If that well is put in, it's likely to produce for decades. So you want to be very comfortable in that legal document, because that's going to create the relationship not only between you and the company that you've leased to, but your children, your successors, the people who buy that property, and whomever may end up operating that lease for decades to come.
I mean, they don't know too much about it, but how would someone find a lawyer or, to protect their rights?
All you need to do is Google Marcellus Shale in Pennsylvania, and you will find them.
You wouldn't give any recommendations then for anybody?
No.
Okay. My second question, if I could, you mentioned that groundwater contamination by hydrofracking. There's never been an incident, you said. What do you mean by that? As far as
what do I mean?
Well, for example, there's a Dimock, Pennsylvania.
Yep.
You might have heard of that.
I'm well aware of it.
And Maria Ladoyer, who did the first presentation, mentioned that. She basically mentioned that it was, it was a gas company that had gone wrong, and basically there was a few wells that were contaminated. So, is that in opposition to your statement, or can you clarify what you mean by what you said?
No, what I mean by hydrofracking is quite literally hydrofracking. It's a completion technique. After the well has been drilled, cemented, cased, you perforate it, you then go in and actually conduct hydrofracking, which is putting in the fracking fluid and additives under pressure to break apart the rock. That's hydrofracking. What happened in Dimock is a situation that could happen any well, frankly. In Pennsylvania, they don't have midsection casing regulations like they have in New York. So they can actually drill down and not case. They sleeve with pipe, but they don't necessarily have to cement case the entire wellbore. And in Dimock, the company that was doing it, as I understand it, did not cement the entire production section, which is actually not what you think it is. It's the vertical section, all the way back to surface. And gas migrated into the annular space between the steel pipe and the host rock, fairly near surface, and migrated into the groundwater. It was a drilling problem, not a hydraulic fracturing problem.
I have a question about the leasing rights. You mentioned the rules regarding compulsory
Integration.
Integration, thank you. And that applies to the people who own the mineral rights.
Correct.
If you own the surface but not the mineral rights, do you have anything to say about what happens under your property?
No, actually. Many people don't realize this, but as in between a mineral estate and a surface estate, I mean, the estate and land, a legal estate, the mineral estate is dominant. And very few people realize that. So if you are buying a piece of property, one of the more important things to determine is whether or not you're buying the minerals with the surface. Because if they have been severed, very typical in Pennsylvania, not as common in New York, but you do see it. If that suite of minerals has been severed from the surface, the company comes around to lease or to integrate for that matter, they're going to integrate the mineral estate. And there's very little that very few rights that a surface owner has. There is some momentum in Pennsylvania where it's fairly common to have severed estates for the legislature to create a so-called Surface Owner's Bill of Rights, which would enable a surface owner to have and enjoy more rights than they have now. Additional setback provisions, a requirement for negotiation in good faith over the location of wells, access roads, pipelines. That's not presently the law.
Yeah, that's what I was going to ask. I mean, they can't develop their mineral rights without coming through the surface. And so does that mean they can drive into your back field and drill a well?
Yep. That's exactly what it means.
Yeah,
and that's exactly what happens. As I said, it's very common in Pennsylvania. What you normally will find is that companies will use what I would call reasonable best efforts to avoid those types of circumstances. They're going to be operating more than one well. They're going to be operating for more than a week. They're going to be in these communities for a long time. And it just does not make good business sense to tread on the landowner's rights. So, some good sense has to be paid to the way that it's done. But where you do have problems are a property owner who bought the property, mineral rights were severed, leasing is now going at $5,000 or $6,000 an acre. The neighbors are driving, new cars and improving their homes, and you end up not only missing out on the economic opportunities, but end up with a well in your backyard. And that does create some unfortunate tension, as you can imagine. Yes?
Given that there have been people gotten ill, and the Department of Health has not completed an investigation and determined one way or another whether wells cause illness.
I didn't give that.
Well, you said that the Department of Health is where you should report
where you
cases
should go.
of illness, and they should investigate. Is it not wise for New York State residents to wait until there is a determination as to whether wells cause problems? I don't think that anybody here is against energy or economy, but is it not wiser to wait and see than it is to move forward and pay the consequences later?
It's the wait and see aspect of it is what I don't quite understand. I mean, this is an ongoing process. Presumably these incidents, if they've occurred, have already happened as a result of conventional drilling, and they should have been reported to the Department of Health in real time as it happened. There's ample opportunity for those things to have been investigated, and the Department of Health is out routinely looking into every incident that gets reported to them, and to my knowledge has never found anything. In Pennsylvania, they have a very similar process, and in fact, they have a law that New York doesn't have. There is a setback requirement of 1,000 feet around a well, and if there is any modification, I think that's the word that they use in the statute, to the water around a drill site within 1,000 feet, the presumption is that the drilling operations caused it. Doesn't matter what it is, whether it's a diminution in quantity, quality, doesn't matter. The presumption is that the operator caused it, and the practice is to obtain water samples before drilling, so that if an incident is reported and the county does sample the water, there's a control sample to measure it against, or multiple control samples. So it's an ongoing process. I don't think there's something to wait for. And the question is, what if it's not the water that's making the mill? Frankly, I'm not sure what the different possibilities would be. I mean, it's water or airborne. Presumably, if there's an airborne pollutant, that too is under the jurisdiction of the Department of Health to investigate. I mean, I think we could postulate any number of scenarios, but in the absence of any tangible evidence that they've occurred, there's nothing to evaluate.
I'd like to go back to the discussion that started about the Energy Policy Act of 2005
Sure.
and the exemption for the Clean Water Act and the legalities of that. I mean, it fascinates me that every time I hear a speaker from the industry or even yourself say that there's not one proven case of water contamination or anybody being harmed by this process, it fascinates me because clearly there are problems. And so I think the disconnect, perhaps, and maybe you can help shed some light on this for me, is that what that exemption, that federal exemption does is it effectively throws it back on the states to say, it's up to you to decide how you're going to use your water resources. And frankly, the amount of water that it takes to drill these wells, and if it does move forward, it could be billions of gallons of water. It's not the water, it's the chemicals put in the water. So you can say, I'm sorry, I'm just really upset because I keep hearing people say that, and I personally know people that are affected by the process. So my question is just, where do you see that, where do you see the states, you seem to be very upset about the fact that this can't move forward. So can you at least speak to why we shouldn't have the state looking at regulation to manage our water supplies more effectively when it comes to this process?
I think that not only should the state look at it, the state is looking at it. And frankly, the state has done a very good job of doing it since the DEC was created. New York has the most stringent drilling regulations already on the books of any state in the country. They've been very proactive in terms of updating the regulations, in terms of updating the statutory scheme for regulation, and their history of regulation demonstrates that they have done a very good and a very effective job at regulating the industry. I am not against any degree of regulation. All I would like to see is process predictability. If you know what the regulations are, you can comply with them. It's when the process, and it should incidentally be an evolving process. I'm not suggesting that it's static, we stop today, we don't look at anything new. Of course you do. As you get additional data, you take that into consideration, you modify the regulatory program accordingly. That's what states do. And states do regulate the oil and gas industry because of its fundamental real property rights nature, and that's who regulates real property rights. The EPA has time and again said that it is, until 2 days ago, that it is not the applicable regulatory agency to regulate hydrofracking and natural gas drilling. Much of that has to do with the fact that at the state level, drilling permits are conditioned on a site-specific basis. So when you apply for a permit from the New York State Department of Environmental Conservation, before the permit is issued, the DEC does an independent scope of the project. The DEC looks at the proximity to groundwater tables, looks at the depth of potable groundwater in the area, designs a well-specific casing program to take into account protections of those potable aquifer zones. The DEC is on site to physically inspect the well as it's drilled through the aquifer zones and to assure that the well is cemented back to surface to protect those aquifer zones. These are not the types of things that the EPA does, and these are not the types of, in fact, these are the things the EPA says it doesn't do well. So I think there is, to me, there's a disconnect in thinking for some reason that the federal regulatory agency is going to do a better job of it than the states are going to do. I personally don't see that. But if that is the regulatory program, so be it. As long as you know what the program is, you can comply with it. In terms of the 2005 Energy Act, I've lectured on this so-called exemption many times. It's not an exemption. It's a recognition that hydraulic fracturing has never been regulated by the EPA under the Safe Drinking Water Act. How that has been morphed into an exemption, I don't know. Even the EPA has said it's not an exemption. And that's the legal process.
I have a very specific question about oil gas lease.
Sure.
They all have a statement that the gas company will pay a fee per acreage if there's no activity during a year. Now, if that fee is no longer paid, does that terminate the lease?
It did. What you're referring to is a delay rental clause.
Right.
And the delay rental clause was in leases historically actually for the benefit of the operating company. What they would do is take a lease and say they provided $5 per acre as a signing bonus. They then have an obligation to develop that lease. And so to give them the right to delay development, they put in a delay rental clause that they would pay annually. Well, landowners got pretty savvy to that, and recognizing the time value of money said, why would I want to get $5 an acre per year over 5 years? Just give me $25 an acre now. And that's what you've actually seen is the evolution of a delay rental lease into what you'll now see referred to as a paid-up lease. Process is still the same, but all the money's paid up front.
Thank you, Michael. Just a question about, I'm just a listening citizen, don't
Sure.
have any vested interest in this at all. It seems like the process has an enormous amount of wastewater involved, the hydrofracking process, with the toxins included. Who's liable for the disposal of that enormous quantity of fluids? It's kind of an understanding that some of it may be stored on site in some kind of ponds and so forth. Who's liable for that fluid? And what about people that live around it that don't live on the land, but like, let's say the neighbors, who have to put up with a large volume of vehicles, the trucks coming in and out? What kind of legal rights do they have to speak against what's going on? So those two areas, please.
On the issue of water, enormous is relative. Certainly we are talking 3 to 5 million gallons on a well. What's now happening is the industry is moving towards, if you can use enormous, I can use mass recycling. What we're now seeing is some companies getting upwards of recycling 100% of their flowback fluid to use it again. After that fluid no longer can be used again, they can't manage the salts anymore, the operator is required to arrange for disposal. And they have a manifest system just like you would any other type of hazardous waste. For a long time, ironically, most of the drilling fluid in Pennsylvania was coming into New York. That process has largely been stopped. What we're now seeing is end-of-life fluid that's been recycled multiple times now, or more commonly than not, being sent to disposal wells. There's a number of them in Ohio that are taking it. There's a number of disposal wells in Pennsylvania that are near the end of the completion of the EPA review process. So that's the likely source of them. But from cradle to grave, they're the responsibility of the operator, barring negligence or something on behalf of a transporter, a vehicle spill, for instance. The second portion of your question was involving trucks and neighborhood rights? Yes. Okay. Generally, the answer is you don't have legal rights. Your neighbors, given that they have those property rights, have the right to enjoy the development of the property in the same way that you would have the right to enjoy the development of yours. The corollary is not necessarily true. If you choose not to develop your property, which certainly is your choice, you can't prevent your neighbor from doing it.
Mike, let's take just one or two more questions.
Sure.
I apologize for my diatribe before. I mean, maybe I've been misinformed, but you mentioned, like, perhaps I've been susceptible, like, to the propaganda and whatnot. But do you have, so I can re-educate myself, do you have the name of the study, any studies that have been done proving that the people aren't getting sick from, like, either the hydrofracking process or the fluid? And if so, like, could you, like, make it, post it somewhere or something? I mean, do you have one, or?
The best one that I would direct you to on a national level is the study that was completed by the EPA in 2005 that studied, I'm going to round it down to 1.1 million wells. They studied the hydraulic fracturing impacts on 1.1 million wells, and the EPA concluded there was 0 impacts. That study is readily available by just Googling EPA 2005 and hydraulic fracturing.
Okay. You don't off the top of your head know what states they cited or the statistical methodology or anything like that, right? Do you or
States
no?
that they looked at in particular in that study involved, I think they spent some heavy focus on the Black Warrior Basin in Alabama. I know that they looked extensively at western Colorado. I want to say that they were looking at play in North Dakota, but it was fairly comprehensive. I mean, they looked at just about every piece of information out there. There was 20 states that reported.
Did they include Pennsylvania or the ones that are kind of contentious states?
Well, bear in mind that,
people have
for
been-
instance, the Marcellus Shale wasn't developed until 2008. So that would not have been included in that particular study, no.
Well, then how can we have accurate data if it wasn't included in the study?
Well, that's a study that was done before the wells were drilled. You can look for updated information from the state regulatory bodies that have to publish that information, generally speaking, annually.
Do you know where I can find that, or?
Actually, we are working with the University of Buffalo Geology Department to possibly put together a data repository for that type of information. Because I'll be the first to tell you, it's not in any consolidated place that I could point you to. One of the issues is that you do need some type of a neutral educational body to have credibility to house that type of information.
Right.
If I were to direct you to Halliburton's website, you would go out of here just mad. It's not going to do any good. Most of that stuff is kept by the Department of Energy, very good resource, and the individual states, the conservation agencies, very good resources. New York State DEC's scoping document extensively discussed that issue as it relates to its experience in New York. So you can look there as well.
Do you know of any information regarding like money spent? Because you mentioned like maybe why things happen in Pennsylvania is because of the drilling technique, like poor regulation, they don't have the cement casing or whatever. Like, do they have any studies relating to that specifically, or like the types of like casings and how stuff maybe will spread out of them?
Specifically to DIMIC, I'm not aware. I don't know.
Let's wrap it up at this time. It's been quite a few questions here. I think that's about 45 minutes worth of questions. So we got a lot of really good variety of questions here. So thank you very much for coming and asking.